So, meanwhile, back to Title II. Covers all programs and activities, whether provided directly or indirectly through contracts. There are some administrative requirements. Keep in mind, the ADA was passed in 1990, 34 years ago. And most of the administrative tasks that were required under Title II were supposed to have been done in the 90s, right? And probably they were, but now it's time to dust them off and take another look at them. 34 years later, a self-evaluation should be completed that identifies barriers to activities and services, and a transition plan should be developed that sets forth a schedule to make structural changes if needed. You should develop and publish a grievance procedure, and you should designate an individual to oversee compliance efforts. How is Title II enforced? You can file a complaint of the public entity's grievance procedure, and wouldn't you rather have that, a grievance filed, than a lawsuit, right? Of course you would. You can probably resolve a grievance at the local level, you hear the complaint, you take care of it, end of story. Rather than having a lawsuit or a complaint filed with the Department of Justice. So you want to have a robust grievance procedure. The grievance procedure should have a description of how and where to file a complaint. It should have a statement notifying the potential complainant that there are alternate means of filing, and those will be available if needed. So if you have someone who is blind, for example, who wants to file a grievance, how are they going to do that? You need to be thinking ahead about how would those grievances be handled. A description of the time frame and the process to be followed by a complainant and the government entity, and information on how to appeal an adverse decision. So I don't like what you came out of the grievance procedure. Is there another step? Can I kick it up to a higher level, or do I have to get an attorney and file a lawsuit or file a grievance or file a complaint with the Department of Justice? And a statement of how long the complaint files will be retained. How long are you going to hold on to that complaint? So the key concept under Title II, the one thing you need to remember is program accessibility, right? A public entity's services, programs, or activities, when viewed in their entirety, must be readily accessible to and usable by individuals with disabilities. What does that mean? Well, it means that not every room and every building needs to be accessible. The programs that are operated by a state or local government entity must be accessible. And almost everything you do is a program of the local government, right? This building is a program of the county. The parking lot is a program of the county. If we look at that, from a total, it needs to be accessible and usable by people with disabilities. So I like to use the example of parks. How many parks are there in Alachua County? 28. Oh, I would think there's more than that, but okay. 28. That are managed by the county. All right, so when we look at parks, all those 28 parks, not every one of them and every piece of equipment in every one of them needs to be accessible. But when we look at the parks in total, there should be accessibility within the parks. There should be some of those parks that have accessible playgrounds, accessible elements, and they need to be scattered about so that it's not all in one location, right? But when we look at parks from the bird's eye view, there should be accessibility. That doesn't mean that every piece of equipment needs to be accessible, but when I look at the parks in total, when I look at its entirety, there should be accessibility within it. And think about the other programs and things that you have. How many are accessible, how many are not? Now, the ADA, and certainly under Title II, 34 years since the enactment of the law, you should be moving toward making 100% of them accessible, but you don't have to have every room and every building accessible. But the programs that are operated there, need to be accessible to people with disabilities. Does that make sense? So this is directly from the Technical Assistance Manual. A public entity may not deny the benefits of its programs, activities, and services to individuals with disabilities because its facilities are inaccessible. A public entity's services, programs, and activities, when viewed in their entirety, must be readily accessible to and usable by individuals with disabilities. This standard is known as program accessibility and applies to all existing facilities of a public entity. Public entities, however, are not necessarily required to make each of their existing facilities accessible. The room doesn't have to be accessible, but the program needs to be accessible. I need to be able to provide it. For example, I did an evaluation of the courthouse in Kissimmee for Osceola County. This was 20 years ago I did this evaluation. And, you know, it's a beautiful courthouse. Disney's used it in some of their movies. It's right out of Gone with the Wind. It's so beautiful, historic building with 100 steps to the front door. Little tiny hallways that are probably 24-inch wide in some of the areas, you know, very narrow doorways, completely inaccessible. And back then, if you wanted to get a marriage license, you had to go down this little hallway and around a corner and up a couple of steps, and the lady that was giving marriage licenses, that's where her office was, and that's where you had to go. Completely inaccessible. But if you had an individual with a disability, you could make an appointment at the annex across the street, and they would give you a marriage license over there, right? Because you couldn't get to this particular office. That's program accessibility. Providing the program of getting a marriage license in an accessible location may not be where most people go, but because it was accessible across the street, that's program accessibility. Being able to get the service in an accessible location that may not be the original location, but that's okay as long as it's available, as long as it's accessible, right? Doesn't require all buildings and facilities to be accessible, but priority must be given to the method that results in the most integrated setting, and it may include providing aids, equipment, or relocating a program. So, what's a self-evaluation? Oh, that's a review of the policies and practices, including communications and employment. And through that self-evaluation, the public entity should identify any policies or practices that do not comply and modify policies and practices to bring them into compliance. That's a self-evaluation. A transition plan a public entity should develop a transition plan that's structural in nature, that goes to existing facilities a transition plan when structural changes to existing facilities are necessary in order to make the program or activity accessible to people. The plan should identify the methods to be used, should provide a schedule, and should identify the responsible individual. So there should have been this plan developed a long time ago. But guess what? Lots of things have changed in 34 years. New programs have come online. And again, it's the program that needs to be accessible, not necessarily the building. So when you start a new program in the Parks Department or in, pick your department, new programs that are coming online, are they accessible? What are the policies and procedures that we implement to start that program? Are they discriminatory in some way? Are we screening out people who have disabilities rather than screening them in? So some of the general non-discrimination provisions: you cannot refuse to provide services to an individual with a disability. There should be maximum integration. You cannot require participation in separate programs. You can have separate programs, but you can't require that a person with a disability only be in the separate program. What do I mean by that? Well, let's think about summer camp, right? You probably have a summer camp for kids. And in that summer camp, there's, football, baseball, basketball, swimming, I don't know what sports you might be doing, but you're doing activities that some kids are not going to be able to participate in because of their disability, right? So you can have a separate program for them. And they may choose to participate in that program because they're doing things that are adaptive recreational activities designed for kids with disabilities. If we have one of those kids who wants to be in the main program, you can't deny them access to that, right? They want to be in that program because that's where all their friends are. Even though they may not be able to participate in some of the activities, if that's where they want to be, they're allowed to do that. Yes, you can have separate programs, but you can't mandate that a person with a disability be in that separate program. Make sense? You need to anticipate the needs of people with disabilities. For example, do you know how to get a sign language interpreter for a meeting? What would you do if you had a request for electronic format of the agenda of your meeting, or a braille version of that? How do you get that kind of stuff accomplished? You should think ahead and be prepared, anticipate the needs of people with disabilities that are going to be in your programs and services. How are you going to accommodate them? Be prepared. You can't have any special requirements. You must provide reasonable accommodations for people and make reasonable modifications in structures if necessary. A lot of local governments over the last 30 years have taken a pretty aggressive approach to making physical changes. And first, when we started out doing this work, it was, well, how can we relocate that program? How can I get that marriage license in Kissimmee so that, they can meet across the street at the annex? Now, after 30-some years, a lot of local governments have done structural changes to make sure that those buildings are accessible. I haven't been back in the courthouse over there, so I don't know what it looks like these days. I don't think they did much work on it because it's like a historic building. But they've moved those programs to the annex across the street where it's accessible, right? And a lot of local governments, I can speak on behalf of St. Petersburg, have taken a pretty aggressive approach to removing barriers, making their buildings accessible, making sure their restrooms are accessible and access is available so that we don't have to worry about relocating a program. The buildings now are much more accessible. And again, you cannot charge surcharges. People with disabilities must not be denied equal opportunity to participate and benefit. Eligibility criteria that screen out people with disabilities may not be used unless it's necessary for the provision of services and activities, unless it poses a direct threat, right? Same kind of analysis there. Reasonable modifications when necessary to ensure equal opportunity. They must be made to policies, practices, or procedures. Let's talk a little bit about effective communication. For people with disabilities, that effective communication are entitled to auxiliary aids and services unless it would result in a fundamental alteration, an undue burden, or a hardship. And again, for Title II entities, that undue burden or hardship is a pretty high bar to meet. Effective communication should be as effective as communication with others. It may involve auxiliary aids and services, including interpreters, telecommunications devices, large print, braille, and priority should be given to the preferred method for public entities. Again, Title II entities have a higher obligation to provide the preferred mode of communication that individual with a disability requests. Effective communication may mean real-time transcription or CART. This is a picture of a CAPI meeting, which is a Citizens Advisory Committee meeting in St. Petersburg, where the chairman at that time was a lady who was late deafened. She became deaf after getting her college degree. And so she didn't use sign language. She used CART, or computer-assisted transcription, that allowed like a court reporter sitting next to her to type what the proceedings were going on, and it appeared on the laptop on the desk in front of her so she could follow. In fact, she was chairing the meeting. Those kind of accommodations are required. For many individuals who are deaf, a sign language interpreter may be the only truly effective means of communication. And I just want to stop here and talk about that issue. Imagine you were born deaf, right? You never heard your mother's voice, never heard your father's voice, never heard your teacher's voice. You were born deaf and have never heard a sound. How hard do you think it would be to learn to read? Pretty darn tough, right? I'm going to learn English without ever hearing a sound. Hooked on phonics doesn't work, all right? So you may have an individual who is deaf, profoundly deaf from birth, who may have a very high IQ. It could be a genius level, but they're reading at a 4th, 5th grade level because of the difficulty learning to read without being able to hear. Now we're going to put that person into a meeting, and we're going to write notes back and forth to them about their medical condition, their legal status, their divorce, the birth of their child, and we're going to write notes back and forth to that person. How effective do you think that communication would be? Not very effective. People who are profoundly deaf use American Sign Language, which is not English, doesn't follow the English syntax, much different than English, and they need a qualified interpreter in order to effectively communicate. It's not even like a person who speaks a foreign language because they can't hear. They're not, and they may not be able to read very well or read English very well. So in those situations, the only effective means of communication may be an American Sign Language interpreter, particularly when we're talking about complex, important matters that may affect that person's life. It may be a city council meeting or a county commission meeting, maybe a meeting that's going to be impacting their property rights or whatever it might be. Having effective communication in that situation is critical. Okay? So other auxiliary aids in service include qualified interpreters, note takers, computer-aided transcription services, as I mentioned before, assisted listening devices, qualified readers and tape text, audio recordings, braille material, large print materials. Do you know how to get any of those done? Again, be prepared. Know how to get some of that, or know who to call if you need to get those services for a citizen in one of your programs. Okay? When an auxiliary aid or service is required, the public entity must provide an opportunity for individuals with disabilities to request the auxiliary aids and service of their choice and must give primary consideration to the choice expressed by that individual. This is unique to Title II entities. A Title III entity doesn't have to provide the preferred mode, but a Title II entity does. Primary consideration means that the public entity must honor that choice unless it can demonstrate that another equally effective means of communication is available or that the use of the means chosen would result in a fundamental alteration in the service, program, or activity or in an undue financial and administrative burden. So you have an obligation when somebody requests a sign language interpreter, an American Sign Language interpreter, you have an obligation to try to provide that preferred mode of communication for that individual. Now, you have on your notices, I'm sure, a statement that says if you need accommodation in order to participate in this program, call such and such a number or contact so-and-so. And it probably says something like within 48 hours of the event, or maybe it's 72, or I'm not sure what it says. But it probably has a time frame that you're supposed to do that. And that's appropriate. It takes time to get a sign language interpreter at a function like that. But if they ask for that the day of the event, if they ask for that 2 2 hours before they ask for a sign language interpreter, you have an obligation to make a good faith effort to try to provide that preferred mode of communication. It may be that you have to postpone the meeting in order to get the interpreter there, but you have an obligation under Title II to provide the preferred mode, even if it's within the 48-hour notice that you posted on your notice, right? They didn't know they were going to need to be there until 24 hours before, and they notify it. You have an obligation to make a good faith effort to give it a try, to call that interpreter and see if they can come. They may not be able to, and you may have to reschedule the meeting, but you have an obligation to try. Okay? A qualified interpreter is defined as an interpreter who via video remote interpreting or on-site appearance is able to interpret effectively, accurately, impartially, both receptively and expressively using any necessary specialized vocabulary. It includes sign language interpreters, oral transliterators, and cued language transliterators. I can sign, and at one time in my life I was actually certified as an interpreter, but that was a long time ago and I don't use it very much anymore. I am not a qualified interpreter. I can communicate pretty effectively what I'm trying to say to a person who is deaf. I can sign enough for them to understand me. But when they start signing back to me, whoa, slow down. You know, being able to understand them is much more difficult than me conveying my message to them. So the point is, you need a qualified interpreter, and you need one that's impartial. I've told this story now. This will be the fourth time I've told this story. But, years ago, I ran a program where we helped people with any kind of disability get an apartment, affordable housing, right? And of course, we had a waiting list. Well, a lady comes up to the top of the list. We send a letter, come in for the appointment. You're at the top of the waiting list, not knowing that she was deaf. So she arrives at the appointment with her mother, and her mother says, oh, I can be the interpreter. I will interpret for you. And they have the meeting, and we find out later that the mother has told her that she must, by law, accept this apartment and move out of the home that she's living in, and she cannot have her boyfriend move in with her. Both of those were not true, right? That's not the message that we gave her, but that's what the mother told her we said. And so it just goes to show that you want an impartial, ethical interpreter who's qualified and able to, legally provide the information accurately on both sides. Okay. Common errors are not responding to requests. You just don't respond to a request. Not asking about the preferred mode of communication. Do you need an ASL interpreter or do you need something else, right? Not providing the aid in a timely manner or relying on unqualified interpreters. Like if you were relying on me to be the interpreter, that would be an unqualified interpreter. I can sign a little, but I'm no interpreter. Only using children as interpreters is only permissible in an emergency involving imminent threat to the safety or welfare of the individual or the public. You obviously wouldn't want to use the child who is hearing of a deaf parent as the interpreter, only in a situation where there was an accident and you need to know what's going on in the immediate threat right there. Okay? You can't charge a surcharge. That person who needs an interpreter can't be charged extra to attend the meeting. That's something that you need to absorb, and you need to budget for things like reasonable accommodations for employees and interpreters and effective communication services for individuals, citizens that are part of your community. Personal services and devices are not required to be provided. Examples are like wheelchairs, prescription eyeglasses, hearing aids. You're not required to provide those. Personal services do not need to be provided in activities such as eating, toileting, and dressing, unless that's something that was typically provided by the entity, in like a nursing home or something of that nature. Okay, so let's talk a little bit about direct threat. a person with a disability may be excluded if he or she poses a direct threat to the health or safety of others. And that's defined as a significant risk of substantial harm. A specific risk must be current and identifiable. It must be based on objective medical or factual evidence, and you need to consider whether the risk can be eliminated or reduced below the direct threat level by providing some type of accommodation. So there are situations where a person poses a direct threat. During the pandemic, both EEOC and the Department of Justice said a person with COVID is a direct threat. You can prohibit them from coming to work or from participating in any activity where they might endanger others. There was a specific risk of substantial harm. It was current and identifiable. It was based on objective medical and factual evidence, and there was at that time no way to reduce that risk. Factors to be considered are the duration of the risk, the nature and severity of potential harm, the likelihood that harm would occur, the imminence of potential harm. Let's take a person, for example, with a seizure disorder. You automatically think, well, the person has a seizure disorder, they shouldn't be participating in this program. Well, you need to do an analysis. What kind of seizures does this individual have? How often do they have them? Maybe they are on medication, they haven't had a seizure in 5 years. Or maybe they're having seizures every 5 minutes. You need to evaluate what is the situation. If they have a seizure, are they a danger to themselves or others? Or are they simply sitting in a chair and nodding off as part of their seizure? What kind of seizures are they having? I'm just using that as an example. You need to look at the specifics of that situation and that individual and evaluate on a case-by-case basis before you jump to the conclusion that this person has X, Y, and Z and they're not going to participate. Well, before you do that, go through the analysis. Is it really a direct threat, or are we panicking here? Okay? Lots and lots of lawsuits going on right now over web content. And there are attorneys and their friends who are suing local governments because their websites are not accessible. And they're not accessible to individuals, primarily for individuals who are blind and are using screen readers. And the method of accessing websites for individuals who are blind is a screen reader that reads everything that's on the screen. Well, you can imagine looking at websites that have lots of pictures and movies and arrows, and how do you put that in text? And there are ways to do that. And the Department of Justice, just in April of this year, published their final rule on web accessibility specific to Title II entities. This only pertains to Title II entities. The rule has specific requirements to make sure your web content and mobile apps are accessible. And the standard that they picked is the Web Content Accessibility Guidelines, version 2.1, level AA. For those of you in the tech world, you might know what that means. I am not a techie, but it's a very specific kind of a program that allows you to convert what's on your website into text so that a screen reader can read it. And it does things like labels pictures with a description of what that picture is and gives guidance on how to access your website. For local governments with populations of 50,000 or more, the date of compliance is April 24th of 2026. So there's a couple years to bring your website into compliance. This will help with some of the lawsuits that are occurring all over the state of Florida and the country. There are exceptions to the web content. Archived web content is not required to be accessible. Pre-existing conventional electronic documents and pre-existing social media posts are not required to be accessible. Content posted by a third party where that third party is not posting due to arrangements with the state or local government. Like a citizen just posts something on your site, that doesn't have to be accessible. And individualized documents that are password protected. So you may have some internal communications that are password protected that would not be made accessible through this standard. Okay, what's a wheelchair? We all think we know what a wheelchair is, right? Of course we do. It's defined as a manually operated or power-driven device designed primarily for use by an individual with a mobility disability for the main purpose of indoor or both indoor and outdoor locomotion. So why do we need a definition of a wheelchair? Because some people use other things, right? Some people use a lawnmower for their wheelchair, or a golf cart, or an all-terrain vehicle. So we need to define what a wheelchair is so that we can say if it's not one of those, you can't bring it in here, right? And so what we have is a definition that says wheelchairs, covered entities must permit individuals with mobility disabilities to use wheelchairs in any area open to pedestrian use. So if it meets that prior definition, then you can bring it in. It must allow individuals with mobility disabilities to use manually powered mobility aids like walkers, crutches, canes, braces, and other similar devices in areas that are open to pedestrian use. So they can go anywhere that pedestrians are allowed. An other power-driven mobility device is defined as a mobility device powered by batteries, fuel, or other engines, whether or not designed primarily for use by individuals with mobility disabilities, that is used by them for the purposes of locomotion. So we have situations where things like a Segway are used as a mobility device, and there's actually a Vets with Segways organization for vets who have double amputations, and the Segways have a seat about halfway up so that the individual sits on that seat and is eye-to-eye level with you, not sitting down at a wheelchair height. And so those have been banned at Disney, for example, because Disney thinks they're unsafe with the number of people at Disney, and people can run over you in these Segways. So they have been banned at Disney. Other kinds of devices also can fall into this category. Things like golf carts, electronic personal assistance devices like a Segway, or any mobility device that is not a wheelchair that is designed to operate in areas without defined pedestrian routes, things like a go-kart or a lawnmower. People use these to get around sometimes, and so you can set standards for what can be used and what cannot be used. Covered entities must make reasonable modifications to permit individuals with these devices unless they can demonstrate that the class of other power-driven mobility device cannot be operated in accordance with legitimate safety requirements adopted by the entity. And that, factors are like the type, the size, the weight, the dimensions, and the speed of the device. How fast can these things go? I mean, obviously, if you're in a go-kart, you can go pretty quick. And an all-terrain vehicle can certainly go fast. You wouldn't want a lawnmower coming into this room, right, with a gas-powered engine. Those kinds of things. You can set requirements that prohibit that. The facility's design, like is it indoor or outdoors? How big is it? Is there storage necessary? What's the volume of pedestrian traffic? This is where Disney was at, right? They have these huge crowds and they don't want people getting mowed down. There are legitimate safety requirements limiting the speed or the use on escalators or elevators or other areas. Does the other power-driven mobility device create a substantial risk of serious harm to the immediate environment or pose a conflict with regulations? So I thought it was important to kind of go over this because we're seeing more and more of this happening where people are using various devices to get around. We used to say there are no ADA police, but then the Department of Justice instituted the Project Civic Action, and they would go out to Title II entities. These are just the ones in Florida that were, where the Department of Justice has entered consent decrees, settlement agreements with these various local governments, and they would look at their self-evaluations, they would look at their transition plans, and they would come to an agreement on how those local governments should improve their accessibility and their compliance with Title II of the ADA. So if you want more information on this, you go to the ada.gov, go to the Project Civic Action page, and you can pull up all of these settlement agreements with all of the details and all of the stuff that happened in that those local governments have agreed to do. And some of those things are permanent and conspicuous notice to the community about how to file a grievance, establishment of the grievance procedure, establishment of a delivery system and time frames for providing auxiliary aids. How much time do you need to give? What do you need to do to get those services? Installation of assisted listening systems in assembly areas and municipal auditoriums like this room. Is there an assisted listening device here today? Strengthening of 911. In almost every one of those settlement agreements, there's a whole section on access to 911 for people who are hearing impaired. How do they place a 911 call? Now we have the smartphone, and we have a lot more access to 911 services through a smartphone with a deaf individual who can pull up an interpreter, and you can make actually direct 911 calls on your smartphone without being able to speak. Better telephone communication between the government and citizens with hearing and speech impairments. Adoption of procedures for relocating inaccessible activities to accessible locations, and so on. Okay, and now the fun part. Service animals. Any questions about the Project Civic Action stuff that I was just going over? So if you're really a nerd and you want to get into this stuff, go to the DOJ website and you can read all those settlement agreements. Some of it's pretty interesting what they decided. So which one's a service animal? There's only one, right? The winner is a dog. Under the Americans with Disabilities Act, the only service animal is a dog, is a dog, is a dog, until it's a miniature horse. But in almost all situations, I've never actually seen a miniature horse. We'll talk about that in a second. But under the ADA, a service animal is a dog. It's a dog that's been individually trained to perform specific work or task that is directly related to the individual's disability. All right? It's no cats, no ferrets, no monkeys. They may have a monkey in their home, but that is not a service animal under the ADA that they can bring to the county commission meeting, for example. All right? So the ADA Titles 2 and 3 defines it as a dog that is individually trained to work or perform tasks on the benefit of an individual with a disability. This may include a physical, sensory, psychiatric, intellectual, or other mental disability. However, under Title 2 and 3, service animals are limited to dogs, but entities must make reasonable modifications in policies to allow an individual with a disability to use a miniature horse if they have been individually trained to do work or perform tasks for individuals with disabilities. Why a miniature horse, right? Well, miniature horses can actually be trained to do some of the same things as a service animal, like a seeing eye dog. They can be trained to do that. They can be trained to be housebroken, right? They live twice as long as a dog, maybe more than twice as long, and they have a different dander so that an individual who's allergic to a dog might not be allergic to a miniature horse. So that's the answer I got when I asked the question. So a service animal is defined as a dog specifically trained to assist someone with a disability. The work must be directly related to that individual's disabilities. And yes, you can spend $20,000 to $50,000 to train your service animal. You can train your service animal yourself. It doesn't have to go through any special program, but it needs to be individually trained to do a specific task. What is that specific task? It needs to be related to the person's disability. Just being able to sit and speak, like my puppy, does not make him a service animal, and he doesn't really do that anyway. Oh, so what can you ask? There are really only two questions that you can ask. Is this animal required because of a disability? And if I say yes, you can follow up and say, what work or task has this animal been trained to perform? Don't ask what their disability is, but what work or task has it been trained to perform? Now, if I give you a bona fide answer, it guides me because I'm visually impaired, I'm blind. It alerts me to loud noises because I'm hearing impaired. It alerts me to my seizure because I have a seizure disorder and it can tell when I'm having a seizure. It alerts me when I'm about to have a panic attack. It guides me out of the room when there are crowds so that I don't have a panic attack. So it has been individually trained to do something specific to my disability. They don't need to disclose their disability. They probably will if they honestly answer what work or task has it been trained to perform. But they could say, it alerts me to my health condition when it's coming on without revealing that it's a seizure disorder or whatever it is, right? It's been trained to alert me to an impending health problem. That's an adequate response. End of story. It's a service animal. You don't need to go any further. Under the ADA, animals must wear a vest or tags identifying them as service animals. Is that true or false? That's false. They do not need to wear a vest. They're not required to wear a vest or other indicating that they are a service animal, nor is the owner required to provide a doctor's note verifying the animal's function. That is not the same as the Fair Housing Act or the Air Carriers Access Act. Both the Air Carriers Access Act and the Fair Housing Act have other provisions. This is ADA only that we're talking about right here, okay? But you can go online. This is on Amazon. Just the other day, I took this screenshot. I can buy a cute little vest. I can get 50 cards with ADA info that says that this is my service dog for $28. And you will see that that happens a lot. And people will hand you a card that says, this is my service animal. Bogus, right? What work or task has it been trained to perform? Oh. Well, that was a first. The first time I'd done that. Okay. Hopefully it'll work. So, the animal must be under the handler's control at all times. The animal must be leashed, tethered, or harnessed and under voice or signal control at all times. And the handler may be asked to remove the animal if it's not under control. So, what does under control mean? Well, it means it's not running around loose, right? It's not sitting in a shopping cart. It is providing the service that it has been trained to produce, trained to provide. Let's see if, it did work. So, when can a service animal be excluded? If admitting the service animal would fundamentally alter the nature or service of the program, service animals may be prohibited, and if there are legitimate safety requirements. I put the picture of the panda on this because some people take their service animals to zoos, and there have been several situations where the service animal has gotten into it with other animals at the zoo, or more likely, the other animals have gotten into it with the service animal. So, in those situations, they may ask them to leave the service animal at home, but you can't deny the person the right to participate and come to the zoo without their service animal. All right? That makes sense? Out of control let's say where somebody had a service animal in this room right now. If that service animal started barking and barking at me because I'm up here with the microphone or whatever, you could ask them to please remove the animal. The person gets to stay, but the animal would have to go. if they're out of control, quote unquote. Okay? What are the handler's rights? Service animals cannot be denied access to the public buildings and facilities. Service animals cannot be excluded if someone is allergic to dog dander or is fearful of the animal. If the animal is removed, the entity must offer the handler the opportunity to obtain the service without the animal's presence. True or false? Public entities must assist individuals with service animals by providing water for the animal and taking the animal outdoors to eliminate. True or false? That's false. The care of the animal is solely the handler's responsibility. It is not your responsibility to feed or water or take the dog out. And they should be housebroken. Okay? Service dog fraud is a real thing. There are 24 states that have laws criminalizing service animal fraud, including Florida. And this is just another screenshot I took. You can buy a photo thing that says this is your service animal, in this case, an emotional support animal. Emotional support animals are not service animals under the ADA. Let me repeat that. Emotional support animals are not service animals under the ADA. They are service animals under the Fair Housing Act. And if you are renting to a tenant that has an emotional support animal, that is considered a service animal under the Fair Housing Act. You can, in that situation, require that they provide documentation from their medical professional that this emotional support animal is required because of this individual's disability. Okay? But that's fair housing. That is not the ADA. Emotional support animals are not considered service animals under the ADA. And somebody has one of their ID cards that says Fluffy is an emotional support animal. Too bad. They're not allowed, right? If you don't allow pets, you wouldn't allow them. Okay? So in Florida, a person training a service animal has the same rights as a person with a disability, and they can take that dog in training into a public place. Misrepresentation of an animal as a service animal is a misdemeanor in Florida in the second degree, and that person could be required to do 30 hours of community service for organizations that serve individuals with disabilities. I have yet to hear of anybody who's been charged under this provision. This law has been in place now for 4 or 5 years, and I don't know of anybody that's actually been arrested for service animal fraud, but it could happen. And I think this is more of a deterrent to try to discourage people from, passing their dog off as a service animal. Comfort animals, emotional support animals, therapy animals are not considered service animals under the ADA. Having a doctor's letter that someone has a disability and needs an animal for emotional support still doesn't make it a service animal. I don't care if you've got a doctor who says he'll write the letter. If it's an emotional support animal, it's not a service animal, it's a pet under the ADA. Okay? Bonus question. Under Title I of the ADA, employers must allow employees with disabilities to bring a service animal into the workplace. Is that true or false? That's false. We go back to our analysis of Title I and reasonable accommodations, right? There's not a specific definition of service animal under Title I. Employers may have to consider allowing an employee to bring an animal that does not meet the Title II definition of a service animal, such as a therapy animal or emotional support animal, as a reasonable accommodation. So even if it is a service animal or it's an emotional support animal, you have to look at the Title I provisions of, is this a reasonable accommodation that allows this person to perform the essential functions of their job or not? Or is it an undue hardship on me as an employer to have this dog, let's assume it's a dog, in the workplace? If it's an emotional support animal, an emotional support animal could be a cat, right? So, you would have to do the analysis of, is this an undue hardship to allow them to bring their animal to work? Employers do not have to allow an employee to bring an animal into the workplace if it is not needed because of a disability or if it disrupts the workplace. So unless I have a medical need for an emotional support animal, and again, remember when I said that If you request a reasonable accommodation under Title I, you can request documentation of the need for that animal from a medical professional. So if I have a request for an emotional support animal in my workplace, I can request that that employee provide documentation of that. Okay? More information here, same numbers and things that I had on the other slide.
Is that still correct?
Yes, yes, okay. The question is about the Air Carriers Access Act and the Fair Housing Act, and they're allowing emotional support animals. That is true. The Air Carriers Access Act is enforced by the Federal Aviation Commission, not the Department of Justice, and they are currently in the review process for emotional support animals and service animals. And many airlines now are requiring that you pre-register your service animal ahead of your flight, and you provide the documentation that the animal is a service animal, that it's been vaccinated, for example, and they're requiring that information under the Air Carriers Access Act. That is not an ADA standard, that's Air Carriers Access Act, which covers the airlines themselves. Okay? Good question. Any other questions, comments? Oh, no, here we go.
Hello everyone. So if you're renting, going after an apartment or a condo or something like that, and the landlord has two applicants, one that meets all of the requirements, and then the second one meets all of the requirements, but she needs a dog,
Yeah.
to help her because she's blind. So is it against the law for the landlord to choose whoever she wants, or is it the law to choose the person with the disability?
Well, a good question, and this is my opinion. I believe that the landlord can pick who they want. It also depends on how many units and whether the Fair Housing Act even applies. All right? So if this is a unit with 3 units, the Fair Housing Act doesn't even apply, and they can pick who they want. If you have 4 or more units, then the Fair Housing Act applies, but they could still probably pick either one. If they have 1 apartment available and they have 2 applicants, they can pick the best applicant for the thing. Now, normally you would think that's who's got the most money, right? Who's got the better income. That's who I would pick. Okay, other questions, comments? Thank you all very much for your attention. This is my disclaimer. None of this is legal advice.